Good day, ma'am. I'm Molina Radyunsi and I will discuss facts about the case of Villavicencio versus Lucban. Facts. Lucban, as mayor of Manila, ordered the segregated district for the woman of ill repute be closed for the purpose of exterminating vices in the city. The women were kept confined to their houses by the police, where the city authorities made arrangement with the Bureau of Labor for sending the woman to Davao as laborer. Later at midnight of October 25, the police Anton Homan and the mayor descend upon the houses and placed them aboard the steamer. The women were given no opportunity to collect their belongings and thought that they would be brought to the police station for an investigation. They have not been asked if they wish to depart from the region and neither been asked of their consent for the deportation. Upon the arrival in Davao, the provincial governor of Davao had no previous notification that women were prostitutes who have been expelled in the city of Manila. Then the relatives of the deportees presented an application for habeas corpus to the SC. The application alleged the women were illegally deported by the order of Lucban. Lucban and Human admitted certain facts, but prayed that, that the writ should not be granted because the petitioner was not proper parties to the case that it should have begun in Davao because the women are not in their custody now. According to the fiscal attachment, the women were destined to be laborers at good salaries on the hacienda of Inigo and Governor Sales. Fiscal also admitted that the deportation was without consent of the woman.
Ma'am, good day to you, ma'am. And also, good day to you, batchmates. Disclaimer to those going to watch this video. Disclaimer, our video on law are based on actual cases. The facts stated have been made public through publication. Therefore, should any detail specifically of the petitioner dependent or the dependent accused offensive in any ways whatsoever, kindly leave a message and we will be more than happy to oblige to change any detail accordingly. To refresh you, what is habeas of corpus? Habeas of corpus is a fundamental right in the Constitution that protects against unlawful and undefined imprisonment. Trans- Translated from the Latin word, it means "show me the body". Habeas corpus has historically been an important instrument to safeguard individual freedom against arbitrary evacuate, evacuative power. What is due process? Due process balance the power of law of the land and protect the individual person from it. Ma'am, good day, ma'am. I'm Lindsay Tomarjan I, reporting about the issue of Bisilencio versus Lokban. Our issue is whether or not Mayor Lucban has the authority in expelling the prostitutes in the city, Manila, without the due process of law. The Supreme Court says one can search in vain for any law, order, regulation which even hint at the right of the Mayor City of Manila or the Chief of Police has the right to force citizens of the Philippines island and this woman, despite their being in a sense of leader of the society, are nevertheless chattel but Philippine citizens protected by the same constitutional guarantees as are other citizens to change their domicile from the Manila to another locality on the contrary Philippines penal law specifically punishes any public officer not being expressly or not authorized by law or regulation, compel any person to change his residence. Century ago, Magna Carta decreed that no freeman shall be taken or imprisoned or be diseased of his freehold or liberties or free custom or be outlawed or exiled or anywise destroyed, nor will pass upon him nor condemn him but by lawful judgments of his peer by this law of land we will sell no man, we will not deny or defer to any man, neither justice or right nor offense. We will sell no man, we will not deny or defer to any man, neither justice or right, no official, no matter how high, is above the law. The court are the forum which functionate to safeguard individual liberty and to punish official transgressor. The law is the only supreme power in our system of government, and every man whom, by accepting official participates its function, is only more strongly bound to submit to the supremacy and to observe the limitation which impose upon the exercise of the authority, which it gives the very idea of the same high tribunal in another case that one man may be compelled to hold his life or the mean of living or may material or any material right essential to the enjoyment of life at the mere will of another seems to be tolerable in any country where freedom prevails as being the essence of slavery itself. We believe the true principle that if the respondent is within jurisdiction of the court and it has the power to obey the order of the court and those to undo the wrong that he has inflicted. He should be compelled to do so even if the party to whom the writ is addressed has essentially illegally parted with the custody of the person before. The application for the writ is no reason why the writ should not be issued. Yet the mayor and the chief of the police, acting under no authority of law, could be deport this whom from this from the city of Manila to Davao. The same goes to official must necessarily have the same means to return them from Davao to Manila. The respondent within the reach of process may not be permitted to restrain a fellow citizen of her by, by forcing her to change her domicile and to avoid the act with impurity in the court. While that person was with her birthright of liberty has no effective recourse, the great writ of liberty may not thus be easily evaded.
Good day, ma'am. I'm Boca Samantha Grace, and I will be discussing the issue and the held about Villavicencio and Lucban cases. Villavicencio and versus Lucban case is about the prostitution, itong sa deportation nitong mga prostitutes natin sa Davao. According to my groupmates nga, yung nag-report nung nauna, sinabi nila na ayon sa report nila noong March 25, 1919, nangyari itong insidente na to. Si Mayor Lucban nagsagawa siya ng operation or nagsagawa siya ng utos na lahat ng prostitutes sa Manila papalipat nila sa Davao para hindi sila ma-expose pa sa ibang mga tao, para hindi na sila mas lalo pang dumami. Kasi ang tingin nila doon parang nakakasira ng nakakasira ng reputasyon sa Manila kapag maraming mga prostitutes. Kaya nagsagawa siya na nag-utos siya na ipapalipat yung mga prostitutes. Noong October 25, on the same year, Police Anton Yuman and Mayor Lucban magkasama sila na nag-conduct ng operation. Magkasama sila yung nag-uutos, sila yung nangunguna sa operasyon na yon. Yung mga babae pinadala nila sa Davao without consent or any permission. Pinadala nila doon, binigyan lang nila ng pagkakataon na dalhin yung mga gamit. Pinadala nila lahat ng kailangan na gamit, yung mga kakailanganin, mga importante, pero hindi sila pwedeng tumanggi na sumama doon. Kasi ang nangyari sa pilitan lang. Na pinilit sila na dalhin doon, tapos dinala sila sa police station para imbestigahan. Lahat ng gamit nila inimbestigahan bago sila dalhin o ilipat. Ngayon mag-focus tayo dito sa held or yung sa naging hatol. Kasi nagsampa yung mga relatives ng mga biktima ng mga prostitutes or yung mga respondent, yung mga petitioners natin Nagsampa sila ng kaso sa yung mga relatives nagsampa sila ng mga kaso kasi nga syempre, nalabag talaga yung human rights ng mga kababaihan doon. Ngayon, mag-focus tayo, i-discuss ko kung ano nga ba yung naging hatol ng korte according doon sa case nila Villavicencio and Lucban. Let me read this paragraph muna bago ko explain yung talagang naging hatol ng korte, bago ko siya ipaliwanag kung ano yung mga nalabag or ano nga ba talaga yung naging process ng kaso na to. Law defines power. No official, no matter how high, is above the law. Lucban committed the crime that grave abuse of discretion of deporting the prostitutes to a new domicile against their will. There's no law expressly authorizing his action. On the contrary, there is a law punishing public officials not expressly authorized by law or regulations, who compels any person to change his residence. Furthermore, the prostitutes are still as citizens of the Philippines, entitled to the same rights as stipulated in the Bill of Rights as every other citizen. So, sinasabi dito na, kasi nga diba sinabi ko kanina na yung tingin nila dun sa mga prostitutes parang nakakasira ng reputasyon ng city or ng lugar na yon. Kaya parang inalis sila, in-execute sila doon, and-exclude, rather. Diba? Kasi nga, parang nakakasira ng reputasyon or parang nakakasira sa imahe ng Manila Kasi nga, di ba, pinapaganda natin, di ba, parang pinapakita natin na maganda yung image, di ba, pero tinanggal nila kasi nga parang marumi yung tingin nila, hindi maganda sa mata. Dito naman, sinasabi dito na yung mga prostitutes or yung mga babae na yun, meron din namang mga kanya-kanyang karapatan, parehas lang din sa atin. Sa lahat, pantay-pantay ng trato dapat ang binibigay sa kanila. Kasi, di ba, party pa rin sila ng Pilipinas, wala naman silang nilalabag na kahit sabihin na natin, di ba, na mali pa din yung pagka-trabaho ng mga ganon, wala naman silang ginagawa na masama, technically. Their choice of profession should not be a cause of discrimination. Ito sinasabi ko nga na, hindi naman kasi natin alam lahat ng mga reason kaya sila nagtatrabaho ng ganon. It's either poverty, di ba, may problem, financial, of course, kasi ayun naman talaga yung reason, mga common reason kung bakit parang pinapatos na natin yung mga ganon. It may make some, like Lukban, quite uncomfortable but does not authorize anyone to compel said prostitutes to isolate themselves from the rest of human race. These women have been deprived of liberty by being exiled to Davao without even being given an opportunity to collect their belongings, or worse, without even consenting to be transported to Mindanao. For this, Lukban must be severely punished. Sinasabi dito na, ayun nga, di ba, yung mga kababaihan na yun, nakuhaan na sila ng karapatan of liberty. Di ba? Parang, ayun nga, binigyan lang sila ng opportunity na kuhanin lahat ng mga gamit nila. Tapos pwede rin namang hindi. Siguro hindi naman lahat yun na may pagkakataon pa na kuhanin yung mga gamit. Or mas worst pa yung hindi nga sila nabigyan ng consent. Parang sinama sila sa pilitan, wala silang nagawa. Hindi na sila nakalaban. Parang sumunod na lang sila kasi nga parang siguro natakot na rin sila. So doon pa lang talagang malalaman natin na parang tinapakan na yung pagkatao nila or kanilang human rights, di ba? Hindi nirespeto yung kanilang karapatang pantao. Dahil doon sa insidente na yon, si Mayor Lukban talagang naparusahan. Meron ditong article na magsasabi kung ano nga ba yung mga punishment sa mga ganitong mga public official natin gumagawa ng mga ganitong mga wrongdoing, di ba? As to criminal responsibility, it is true that the penal code in the force of this island provides any public officer not thereunto authorized by law by regulations of a general character enforced in the Philippines who shall not banish any person to a place more than 200 kilometers distant from his domicile, except it be by virtue of judgment of the court, shall be punished by a fine of 2 less than 325 and not more than 3,250 pesetas. Sinasabi dito na yung mga public officer daw natin ay hindi sila pinahihintulutan or wala namang law na nag-authorize sa kanila na gawin yon. Halimbawa, yung ililipat mo yung isang tao na without her or his consent, di ba? Walang law na nag-authorize sa kanila na gawin yon unless ito ay inuutos ng judge or sa court kapag may due process tayong tinatawag. Hindi nila pwedeng gawin yon sa mga tao. Halimbawa naman na parang gusto lang nila, parang napatupad na lang sila ng bila ng ganun, walang consent nung, di ba, sa kabilang party. Kaya dito naparusahan si Mayor Lukban at itong parusa sa kanya ay makikita mo sa Article 211. Also, sa Section 2 of Article 2 of the 1987 Constitution of the Republic of the Philippines declares that the state values the dignity of every human person and guarantees full respect for human rights. Sinasabi dito na itong ginawa ni Mr. Lukban or ni Mayor Lukban nilabag itong article na to. 'Di ba? Nilabag niya kasi 'di ba? Dito nga pinoprotektahan natin yung rights ng bawat isa, ng bawat Pilipino. Dito kasi tinanggal niya yung karapatan, hindi niya nirespeto yung karapatang pantao ng mga prostitutes na 'yon. 'Di ba? Kaya dito sinasabi ko na naparusahan siya. Ayun yung naging held o ayun yung naging hatol ng korte sa kanya. Hindi siya tinolerate. Kung nakinig kayo doon sa report ni Mr. Leoncito or ni Batch Leoncito, doon sa issue 'di ba, parang identify mo kung mapaparusahan ba or tama ba yung ginawa ni Mayor Lukban na bigla na lang niya tanggalan ng karapatan yung mga babae or yung mga prostitutes na magsalita na para sa sarili nila. Tanggalin yung karapatan nila na ipagtanggol yung kanilang sarili. 'Di ba, nailipat sila doon na hindi sila pumayag, ganun. Dito, sinasabi dito, whether or not Mayor Lukban has the authority in expelling the prostitutes in his city, Manila to be specific, without due process. So, the answer is no, di ba? Wala siyang karapatan, walang kahit anong law na nag-authorize sa kanya na gawin yung bagay na yun. Hindi siya pwedeng mag-conduct ng ganong kautusan nang wala namang due process. Unless siguro kapag yung judge na or talaga namang hazardous na yung mga babae na yun. Dapat kasi dapat both party nakakapag-usap. Ang nangyari dito sa issue na to, nalabag or natapakan yung human rights ng mga prostitutes kasi wala silang nagawa, hindi sila nakapagsalita, hindi na napagtanggol yung sarili nila. Ayun lang. So, the answer is no, walang karapatan ng kahit sino mang public officers na gawin yun, kanino man.
On November 3, 1998, Sultan Usman Sarangani, Suraida M. Sarangani, and Haji Nur Hassan, in their respective capacity as former municipal mayor, incumbent mayor, and vice mayor of Mandaluyong, filed the instant petition for certiorari and mandamus urging us to nullify the order issued by the COMELEC for having been issued with grave abuse of discretion. Likewise, petitioner moved to consolidate this case with GR number 134456 entitled Sultan Sarangani et al. Versus COMELEC, alleging that GR number 134456 also involves a COMELEC decision declaring the precinct corresponding to 8 barangays in Mandaluyong, Lanao del Sur as ghost precincts issue. Whether or not the respondent COMELEC committed grave abuse of discretion in declaring Padian Torogan as ghost precinct ruling, it must be noted that under the Omnibus Election Code, there should be at least one precinct per barangay. In designating election precinct, the COMELEC usually refers to them by number. Nevertheless, the determination of whether a certain election precinct actually exists or not, and whether the volunteers registered in said precinct are revealed volunteers in a factual matter. On such issue, it is a time-honored precept that factual findings of the COMELEC, based on its own assessment and duly supported by evidence, are conclusive upon this court. More so, in the absence of a substantiated attack on the validity of the same upon review of the records, the court find that the COMELEC had exerted efforts to investigate the fact and verify that there were no public or private buildings in the said place. Hence its conclusion that there were no inhabitants. If there were no inhabitants, a fortu- a fortiori there can be no registered volunteers, or the registered volunteers may have left the place, and it's not impossible for a certain barangays not to actually have inhabitants. Considering that people migrates, a barangay may officially exist on records, and the fact that nobody resides in the place does not result in its automatic cessation as a unit of local government under the Local Government Code of 1991. The abolition of a local government unit (LGU) may be done by Congress in the case of a province, city, municipality, or any other political subdivision. In the case of a barangay, except in Metropolitan Manila area and cultural communities, it may be done by the
Sultan Osman Sarangani versus Comelec. On September 15, 1997, a petition for annulment of several precincts and annulment of Book of Voters in Madalom, Lanao del Sur was filed by the Comelec by Haji Oblais Umar through Council Attorney Nasib D. Yasin. Isa sa pinapaanal ay ang Barangay Padyan, Turugan. The Comelec in telegrams to the respective boards election inspector or BEI about dun sa question precincts in Madalam, Lanao del Sur, including Padyan, Turugan, pinagfa-file sila ng answer of petition for abolition of precincts and annulment of Book of Voters. After that, nag-file ng answer na opposition si Usman Sarangani, yung incumbent mayor ng Madalam, Lanao del Sur, at naka-attach yung affidavit na iba pang oppositors who were allegedly barangay chairman ng 23 barangays na pinapaanal at pinapa-abolish sa Book of Voters. In the affidavits of barangay chairman, they attested that the move of annul of Book of Voters and abolish the question election precincts were for the purpose of diminishing the area of jurisdiction of incumbent mayor of Madalam, Lanao del Sur. After hearing of submission of formal offer of exhibit of memoranda by the parties, Comelec, the issue, dan the order. Nirefer nila ang case sa Law Department for appropriate investigation sa mga alleged gross precincts. So ano kaya ang natuklasan nila sa mga investigation na to? Well, June 18, 1998, nagkaroon ng ocular inspection sa mga sinasabing ghost precincts. 12:10 p.m., pumunta ang Task Force Investigation Team ng Comelec kasama yung mga political leaders, concerned residents ng barangay, representative from Lanao del Sur Provincial Statistic Office na si Lascon Abdullah, at TILG ARMM team sa Barangay Padyan, Turugan, Lanao del Sur. At ang nasaksihan nila ay isang concrete house na walang bubong at isang wooden structure na walang pader at bubong. Obviously, walang tao nakatira sa dalawang structure na to. Bukod pa dun, it came out na yung name ng Padyan, Turugan is actually it's a cemetery na residential place. So, kinokontra din yung record form, the municipal issues, na nagsasabing merong 45 household, total population of 285 dun sa area na yon. Besides, nagtanong-tanong ang chairman ng Comelec Investigation Team sa mga tao doon kung sino sa kanila ang residente o registered voter dun sa Barangay Padyan, Turugan. At wala din namang sumagot. Then at 12:50 p.m., the Comelec investigating team and other went to Barangay Lambak to look for the other supposed a barangay named Rakutan. And after the ocular inspection, report of the result were submitted stating that Padyan, Turugan, and Rakutan were uninhabited.
So on June 29, 1998, the COMELEC issued an order finding Pajan Torongan as a ghost precinct. At dahil doon, mai-exclude na siya for special election to be conducted in Madalom. Kaso, on November 3, 1998, Sultan Osman Sarangani, Suraida Sarangani, and Haji Nur Hassan, and respected capacity of municipal mayor and cabinet mayor, vice mayor of Madalom, filed a petition for certiorari and mandamus kasi gusto nila ma-inilify ng Supreme Court yung order na inisyu ng COMELEC kasi inisyu daw yun with a grave obvious of discretion. So basically, ang issue dito is kung mag-commit nga ba ng grave of obvious of discretion yung COMELEC sa pag-declare sa Pajan Torongan at Agos Precinct. So ano ang say ng Supreme Court? Well, kung titignan yung records, it appears that Pajan Torongan is a barangay in Madalom, Lanao del Sur, and given that it has injurious for COMELEC to consider Pajan Torongan as a ghost precinct. Hindi naman task ng court na i-determine kung barangay nga yung Pajan Torongan or a mere election. Sa petition, nakalagay yung precinct na number 27A located in Barangay Pajan Torongan, yung dineclare ng COMELEC na ghost precinct. Although, dun sa order nila, hindi sila ang nag-mention ng specific tracing. They simply declared Pajan Torongan as a ghost precinct. So to be clear, ang kino-contemplate sa order would be the election precinct in the same people. And under the Omnibus Election Code, dapat merong at least isang precinct per barangay and designated election precinct. The COMELEC usually refers to them by number. Although yung determination if nag-i-exist nga or not ang isang election precinct at kung yung mga voters registered precinct are real voters is a faction matter. Sabi ng AC, sa ganung issue, it is a time-honored precinct that factual finding of COMELEC basis on its own assessment and duly supported by evidence and conclusive upon the court. Lalo na kung wala namang substantiating attack dun sa validity ng mga factual finding ng COMELEC. So upon review of the records, the court finds that the COMELEC had exerted efforts to investigate the facts. Na-verify din naman nila na wala man lang public-private building doon sa lugar. Hence, sa conclusion nila na walang nakatira doon. And if there's no inhabitants, there can be no registered voters or pwede din naman umalis na doon yung registered voters. Hindi din naman daw imposible, sabi ng EC, sa isang barangay na walang actual inhabitants kasi possible naman na nag-migrate daw sila. So, kabarangay may officially exist on record. In the fact that nobody resides the place does not result in the automatic cessation as a unit of local government. Kahit walang nakatira doon sa barangay na yon, hindi pa rin siya i-abolish automatically.
Sangguniang panlalawigan or sangguniang panglungsod concerned subject to the mandatory requirement of a plebiscite conducted for the purpose in the political units affected. The findings of the administrative agency cannot be reversed on appeal or certiorari, particularly when no significant facts and circumstances are shown to have been overlooked or disregarded, which when considered would have substantially affected the outcome of the case. The COMELEC has broad powers to ascertain the true results of an election by means available to it. The assailed order having been issued pursuant to COMELEC's administrative powers and in the absence of any finding of grave abuse of discretion in declaring a precinct as non-existent, said order shall stand. Judicial interference is unnecessary and uncalled for. No voter is disenfranchised because no such voter exists. The sacred right of suffrage guaranteed by the Constitution is not tampered when a list of fictitious voters is excluded from an electoral exercise. Suffrage is conferred by the Constitution only in citizens who are qualified to vote are not others who are qualified to vote and are not otherwise disqualified by the law. On the contrary, such exclusion of non-existent voters all the more protects the validity and credibility of the electoral process as well as the right of suffrage because the electoral will would not be rendered nugatory by the inclusion of some ghost votes. Election laws should give effect to rather than frustrate the will of the people. Wherefore, the petition is hereby dismissed and the assailed order, dated June 29, 1998, of the Commission on Elections is upheld. No pronouncement as to costs. So ordered. Suffrage is conferred by the Constitution only on citizens who are qualified to vote and are not otherwise disqualified by law. On the contrary, such exclusion of non-existent voters all the more protects the validity and credibility of the electoral process as well as the right of suffrage, because the electoral will would not be rendered nugatory by the inclusion of some ghost votes. Election laws should give effect to rather than frustrate the will of the people.
Good afternoon, everyone. My name is Magpaulo T. Asdilla from Foxtrot. I am Group 12B. Ang presentation na ibinigay nila sa amin about kay Erlina Ilosurio versus Erlinda Bildner and Sylvia Ilosurio, John Doe and Jane Doe, by Christine Joyce S. Mendoza. Potenciano and Erlinda was married but separated by bed and board, but lived together for 5 months after going home from New York City, US, due to age and deteriorating health. Erlinda, the wife, filled back for guardianship. Then after Potenciano corporate meeting in Makati, he did not return in Antipolo where his wife is living, which prompted her to file a petition for habeas corpus, which was denied by CA and turned by the CS, and held that the evidence showed that was no actual and effective detention, or deprivation of lawyer. Edit na lang yan. Potensyano illusorious liberty that would justify the, the issue.
Hindi niya na mahal. Mahal niya.
Ang sabi dito, si Potenciano at Erlinda ay kasal ngunit hiwalay sa kama at hindi nakasama. Sabi doon, according to his story, they don't stay together for a long time and live in another country. While they were together, they had 6 children until they reached their right age. In my opinion, it's good to be in the company of someone who understands. No one knows that tree company is solid, but but the, but but when they return home from New York City, their company was different when they set foot in the Philippines. As you see that they don't feel much for each other at that time got home in our country. Ngunit nirahan ng magkasama sa loob ng 5 buwan pagkatapos umuwi mula sa New York City. After 5 months, when they moved in Antipolo area, then Potenciano left the side to their family and husband. It was only about business. He only worked when Potenciano returned to the famous country of New York City after a few months, but he didn't show any sign of it. In my opinion, he planned all that. Dahil sa katandaan at lumalalang kalusugan ni Erlinda, ang misis na field ng guardianship. Tapos pagkatapos ng pa-operate meeting ni Potenciano sa Makati, hindi na siya bumalik sa Antipolo kung saan nakatira ang asawa niya at mga anak niya, which from here to fail petition from habeas corpus. Tinanggi ng CA at pinagtibay ng SC at pinaniwalaan ang ebidensya na nagpakita na walang aktwal at paglabas ng pagpigil o pag-agaw sa kalayaan ng abogado na si Potenciano Serios na magbibigay katwiran sa pagpapalabas ng right.
Hi, my name is Myla Habohad, BS Crim Second Year College student, Section Foxtrot from Group 12B. This is the doctrine on Potencio Illusorio versus Erlinda Blinder and Sylvia Illusorio, John Doe, and Jane Doe. Marital rights, including coverture and living on conjugal dwelling, may not be enforced by the extraordinary writ of habeas corpus. No court is empowered as a judicial authority to compel a husband to live with his wife. Coverture cannot be enforced by compulsion of a writ of habeas corpus carried out by sheriffs or by any other mesne process. That is a matter beyond judicial authority and is best left to the man and woman's free choice. Sabi ng court, hindi daw kasi applicable dito yung writ of habeas corpus because a writ of habeas corpus extend to all cases of illegal confinement or detention or by which the rightful custody of the person is withheld from entitled o sa tulong ng may mataas na katungkulan. When a person continues to be unlawfully denied of one or more of constitutional freedoms, where there is denial of due process, where the restraints are not merely involuntary but are unnecessary, and where the prevention of the freedom, originally valid as later became arbitrary, it is devised a speedy and effectual remedy to relieve person to unlawful restraint as the best and only sufficient to personal freedom, and the purpose of writ of habeas corpus is to inquire into all manner of involuntary restraint and to relieve a person if such restraint is illegal. Wala namang illegal restraint kay Potensyo. So, to justify the grant of the petition, the restraint of liberty must be an illegal and involuntary deprivation of freedom of action. The legal restraint of liberty must be actual or effective the day insurance or the probation of Potentiano's liberty. That was justify the issues once of the said writ right. Sa kasong to, crucial choices involved on his residence and the people he chose to see or live with. The choices he made may not appeal to some of a family member, but these are choices exclusively belongs to Potenciano. The Supreme Court states, however, that the CA exceeded its authority when it awarded restoration rights in the petition for habeas corpus, where Erlinda never even plead for such right kasi daw, when the court ordered the grant visitation, when the court ordered the grant visitation right, it also emphasized that the same should be enforced under penalty of contempt in case of violation or refusal to comply. Such assertion of chronic power is unnecessary. The Court of Appeals missed the fact that the case did not involve the right of a parent to visit a minor child, but the right of the wife to visit a husband in case the husband refuses to see his wife for private reasons. He is not at liberty to do so without threat of any penalty attached to the exercise of his right.
My name is Mary Ann Porta. I'm BS Scream Second Year College from Foxtrot, Group 12B. Facts. Erlinda Calao is the wife of the lawyer of Potenciano Ilusurio. Potenciano Ilusurio is about 86 years of age, possesses an expensive property value at millions of pesos. For many years, he was the chairman of board and president of the Baguio Country Club. On the July 1942, Erlinda Calao and Potenciano contracted marriage and lived together for a period of 30 years. Then, 1972, they separated dead and board for undisclosed reason. For dito sa facts, they describe how rich Potenciano was and how their marriage lived, how long their marriage is 30 years. Then, for anong reason they separately na sila neto. Out of their marriage, spouses had 6 children. 2 of them are inherit respondents, Sylvia and Erlinda. On December 1997, upon Potenciano arrival from the US, so he stayed at Erlinda for about 5 months in Antipolo City. So they have 6 children. 2 of them is Inherit, which is Sylvia and Erlinda. So December 1997, Potenciano arrived from the US and stayed in Erlinda Place for 5 months in Antipolo. Their children, Sylvia and Erlinda, alleged at during this time their mother gave Potenciano an overdose of 200 gram instead of 100 gram Zoloft, an antidepressant drug prescribed by his doctor in New York. As a consequence, Potenciano health deteriorated. Here, so here, Erlinda is gave Potenciano a dosage, twice of the needed dosage that he needs, that prescribed of his doctor in New York. So, because of this, the health of Potenciano is being deteriorated. On Feb 1998, Erlinda then petitioned for guardianship over the person and property of Potenciano Illustrio due to the latter advanced age, frail health, poor eyesight, and impaired judgment. So here, in Feb 1998, Erlinda filed a petition. He really wants to be a guardian for all property of Potenciano. On May 31, 1998, after attending a corporate meeting, Potenciano did not return to Antipolo City and instead lived at Cleveland Condo in Makati. So here, so Potenciano did not go to live in Antipolo with his wife because of the incidents, I thought. So on March 1999, Erlinda filed with the CAA petition for habeas corpus to have the custody of lawyer Potenciano Illustrio. She alleged that respondents refused petitioners' demand to see and visit her husband and prohibited Potasio from returning to Antipolo. So, for this time, March 1999, so Erlinda petitioned for habeas corpus, but but the petitioner demands to visit her husband. So here they are totally separated, and they are not allowed to go and visit and to see Erlinda. The CA denied the petition for lack of unfull restraint or detention of the subject of the petition. Hence, the two petitions were consolidated and are jointly decided. Okay. Issue 1. The petition for habeas corpus is proper.
Potenciano Illusorio versus Erlinda Bilderheld. A writ of habeas corpus extends to all cases of illegal confinement or detention, or by which the rightful custody of a person is withheld from one entitled thereto. A writ of habeas corpus is right of every individual person to have legal or due process to their cases against them that each person has. Example is you can plead not guilty to defend yourself as an accused person. You may presume innocent until not proven guilty. It is available when a person continues to be unlawfully denied of one or more of his constitutional freedoms. where there is denial of due process, where the restraints are not merely involuntary but are unnecessary, and where a deprivation of freedom originally valid has later become arbitrary. It is devised as a speedy and effectual remedy to relieve persons from unlawful restraint as the best and only sufficient defense of personal freedom. The accused can defend himself as long as he wants as part of his right, and he has right to be silent to any allegations that ask to him as part of due process. He also has right to come or not in hearing about his cases if the reason was valid, but he will miss his chance to tell his side to the judge. Any acts that against to his right will become favorable to him in hearing. It advisable to give due process an accused person to be facilitate the case so it will proceed the main case of the accused. The essential object and purpose of the writ of habeas corpus is to inquire into all manner of involuntary restraint and to relieve a person therefrom if such restraint is illegal. The main reason and purpose of the writ of habeas corpus is to prevail the right of every individual on his right to be fair the case by the side of accused, so that the hearing will have peace and acceptable to each side. To justify the grant of the petition, the restraint of liberty must be an illegal and involuntary deprivation of freedom of action. The illegal restraint of liberty must be actual and effective, not merely nominal or moral. To maintain the right of accused, the allegations must be legal with due process. Any restraint to accuse must have permit by judge to maintain equity that not against his right. The evidence shows that there was no actual and effective detention or deprivation of lawyer Potentiano Illusturio's liberty that would justify the issuance of the writ. The fact that lawyer Potentiano is about 86 years of age or under medication does not necessarily render him mentally incapacitated. Soundness of mind does not hinge on age or medical condition, but on the capacity of the individual to discern his actions. The filed case against of the lawyer Potentiano Illusorio is denied by lack of evidence against him to justify by Erlinda. In fact, lawyer Potentiano Illusorio is already at the age of 86 years old. That makes him to be exempted. He is also under medication that cause of not having mentally incapacitated. Although at his age and distress, he can still attend to hearing but not on his capacity to discern his actions. CA observed that he did not request the administrator of the Cleveland condominium not to allow his wife and other children from seeing or visiting him. CA also states that he was sound and alert mind, having answered all the relevant questions to the satisfaction of the court. Based on CA observation, lawyer Potentiano Illusorio did not even request to the administration of the Cleveland condominium to not allow him to visit by his wife and other of his children. CA also states that despite of his age, he can still hear sounds clear and active thinking. He also answered the questions well that asked to him by judge. Potentiano made it clear that he was not prevented from leaving his house or seeing people with that declaration, and absent of any restraining on his liberty. The SC have no reason to reverse the finding of CA. Potentiano Illusorio also presubmit that he was not able to do his want such as going outside or to communicate to people. With this declaration and approved by the SC, they have no reason to accuse him. However, the CA exceeded its authority when it awarded visitation rights in a petition for habeas corpus, where Erlinda never even prayed for such right. However, the CAA gave authority for the visitation rights in a petition for habeas corpus, even she did not ask for it. No court is empowered as a judicial authority to compel a husband to live with his wife. Coverture cannot be enforced by compulsion of a habeas corpus carried out by the sheriffs or by any other means process. That is matter beyond judicial authority and is best left to the man and woman's free choice. There is no law by court or judge that authorized to be forced husband and wife to each other. Coverture or hiding status of a man or woman is not considered by compulsion of writ of habeas corpus or by any other means processed by judicial authority. It is matter the man and woman's free choice.
Good day, ma'am. Good day, batchmates. This is my report. Republic of the Philippines. Jennifer B. Kagandahan. September 12, 2008, 2nd Division. Main facts. On December 11, 2003, respondent Jennifer Kagandahan filed the petition for correction of entries in birth certificate before the Regional Trial Court o RTC, Branch 33 of Sinolaan, Laguna. In her petition, she alleged that she was born on January 13, 1981 and was registered as a female in the certificate of live birth. But while growing up, she developed secondary male characteristics and was diagnosed to have congenital adrenal hyperplasia o CAH, which is a condition where person thus afflicted possess both male and female characteristics. She further alleged that she was diagnosed to have clitoral hypertrophy in her early years and at age 6 underwent an ultrasound where it was discovered that she has small ovaries. At age 13, tests revealed that her ovarian structures had minimized. She has stopped growing and she has no breast or menstrual development. She then alleged that for all interest and appearance as well as in mind and emotion, she has become a male person. Thus she prayed that her birth certificate be corrected such that her gender be changed from female to male and her first name be changed from Jennifer to Jeff. To prove her claim, respondent testified and presented a testimony of Dr. Michael Johnson of the Department of Psychiatry, University of the Philippines, Philippine General Hospital. Dr. Johnson issued a medical certificate stating that respondent condition is known as CAH. He explained that genetically respondent is female, but because her body secretes male hormones, her female organs did not develop normally and she has two sex organs, female and male. He testified that this condition is very rare, that respondent uterus is not fully developed because of lack of female hormones, and that she has no monthly period. He further testified that respondent condition is permanent and recommended the change of gender because respondent has made up her mind, adjusted to her chosen role as male, and the gender change would be advantageous to her. The RTC granted respondent petition. Thus, this petition by the Office of the Solicitor General o OSG seeking a reversal of the above-mentioned ruling. The OSG argues that Rule 108 does not allow change of sex or gender in the birth certificate and respondent's claim. Medical condition known as CAH does not make her a male. Issue: whether the trial court erred in ordering correction of entries in the birth certificate of respondent to change her sex or gender from female to male on the ground of her medical condition known as a CAH and her name from Jennifer to Jeff under Rules 103 and 108 of the Rules of Court. Si Miss Jennifer Kagandahan ay nag-file ng petition sa court noong December 11, 2003 para ma-change ang status at name niya dahil mayroon siyang status na congenital adrenal hyperplasia o CAH. Ito ay isang hereditary o minanang sakit na nandyan na mula pagkapanganak. Ang adrenal glands ay nagtatrabaho ng mas mahirap sa pagtangka nitong mag-produce ng kinakailangang hormones. Dulot nitong overworking at hyperplasia o nagiging sobrang ng laki ang glands. Nagkakaroon siya ng ovary pero maliit ang chances. Hindi rin siya nagkakaroon ng period so siya ay nanindigan na siya ay male hormone. Ngunit hindi ito pinapanigan ng korte. Kahit ito po ay tinetestify ng kanyang doktor. Hindi inaalaw ng korte ang change of status or sex. Hindi daw basihan ang CAH para siya ay maging male. Yun lang po. Thank you.
Respondent undisputedly has CAH. This condition causes the early or inappropriate appearance of male characteristics. A person like respondent with this condition produces too much androgen, a male hormone. A newborn who has X chromosomes coupled with CAH usually has a number 1 swollen clitoris with the urethral opening at the base. An ambitious genitalia often appearing more male than female. Number 2, normal internal structure of the female reproductive tract such as the ovaries, uterus, and fallopian tubes. As the child grows older, some features start to appear male, such as deepening of the voice, facial hair, and failure to menstruate and puberty. About 1 in 10,000 to 18 children are born with CAH. In this case, we consider the compassionate calls for recognition of the virus degrees of intersex as variation which should not be subject to outright denial. It has been suggested that there is a middle ground between the sexes, no man's land for those individuals who are neither truly male or truly female. The current state of the Philippine status apparently compels that a person be classified either as a male or as a female, but this court is not controlled by more appearances when nature itself fundamentally negative such a rigid classification. In instant case, if we determine respondent to be a female, then there is no basis for a change in birth certificate entry for gender. But if we determine based on medical testimony and scientific development showing the respondent to be other than female, then a change in the subject birth certificate entry is an order. Logically, nature endowed respondent with a mixed composition. The respondent has female X chromosomes, however, respondent body system naturally produce high levels of male hormones androgen. As a result, respondent has ambitious genitalia and the phenotypic features of a male. Ultimately, we are of the view that where the person is biologically or natural intersex, the determining factor in his gender classification would be what individual like.
Republic of the Philippines versus Jennifer B. Kagandahan. Issue: whether the trial courts erred in ordering correction of entries in the birth certificate of respondent to change her sex or gender from female to male on the ground of her medical condition known as Ka and her name from Jennifer to Jeff under Rule 103 and 108 of the Rules of the Court. Court ruling. This condition is the properly appearance of male characteristic. A person like responded with this condition produce too much androgen, a male hormone, or a newborn who has XX chromosome coupled with Ka usually has normal internal structure of the female reproductive tract such as ovaries, uterus, and fallopian tubes. As the child grows older, some fractures start to appear male, such as deepening of the voice, facial hair, and failure to menstruate of puberty. About 1 in 10,000 to 18,000 children are born with Ka. In decided this case, we consider the compassionate cause from recognition of the virus degrees of intersex as variations which should not be subject to outright denial. It has been suggested that there is some middle ground between of the sex a no man land from those individuals who are neither truly male or nor truly female. The current state of the Philippine status apparently compels that person be classified either as male or as a female, but this court is not controlled by mere appearances when nature itself fundamentally negotiate such rigid classification. In that instant case, if we determine responded to be a female, then there is no basis for change in the birth certificate entry from gender. But if we determine based on medical testimony and scientific development showing the responded to be other than female, then the change in the subject's birth certificate entry is an order. Biological nature endowed responded with a mix, neither consistently and categorical female, consistently and categorical male. Compassion responded has female. However, responded body system naturally produce high levels of male hormones. As a result, responded has ambitious genitalia and phenotypic features of a male. Ultimately, we are of the view of the person is biological or natural intersex. The determining factor in his gender classification will be what the individual like responded. Having reached the age of majority with good reason think of her sex. Responded here thinks of himself as male and considering that his body produces high levels of more hormones. There is preponderant biological support process for considering him as male. Sexual development in cases of intersex person makes the gender classification at birth inclusive. It is maturity that the gender such person like responded is fixed. Responded here as simply let nature takes its course and has not taken natural steps to arrest or interfere with he was born with, and according he has already ordered his life to that of male. Respondent could have undergo treatment and taken steps like taking lifelong medication to force his body to categorical mold of female, but he did not. He chose not to do so. Nature has instead taken its due course of responded development to reveal more fully is his male characteristic. In that absence of law on matter of the court, he will not dedicate of responded concerning a matter so initially private as one's sexuality and lifestyle. Preference much less on or whether or not do undergo medical treatment to reverse the male tendency due ka. The court will not consider responded as having errand in not choosing to undergo treatment in ordering to become or remain as female. Neither will the court force responded to undergo treatment and to take medication in order to fit the mold of female as society commonly currently know his gender of the human species. Responded is the one who has to live with his intersex anatomy. To him belong a human right to pursue of happiness and of health. To him should be belong to his primordial choice of what courses of action take along the path his sexual development and maturation. In the absence of evidence that responded is an incompetent, and in that absence of evidence to show that classification responded as a male will harm other member of society, who are equally entitled to protection under the law. The court affirms as a valid and justified the respondent position on his personal judgment of being a male. In ruling, we do not more that give respect to the diversity of nature, how individual deal with nature has ended out in the world. We respect responded condition and his mature decision to be a male. Life is already difficult for ordinary person. We cannot be respect how responded deal with his unordinary state of to help make his life easier. Consider the unique circumstance in his case. As for responded change of name under Rule 103, his court has held to change of name in not matter right, but the judicial gain responded to be a female, then there is no basis for change in the birth certificate. Entry from gender. But if we determine based on medical testimony and scientific development showing the respondent to be other than female, then the change in the subject's birth certificate entry is an order. Biological nature endowed responded with a mix, neither consistently and categorical female, consistently and categorical male. Compassion responded has female. However, responded body system naturally produce high levels of male hormones.
As a result, responded has ambitious genitalia and phenotypic features of a male. Ultimately, we are of the view of the person is biological or natural intersex, the determining factor in his gender. Classification will be what the individual like responded. Having reached the age of majority with good reason think of her sex. Responded here thinks of himself as male and considering that his body produces high levels of more hormones. There is preponderant biological support process for considering him as male. Sexual development in cases of intersex person makes the gender classification at birth inclusive. It is maturity that the gender such person like responded is fixed. Responded here as simply let nature takes its course and has not taken natural steps to arrest or interfere with he was born with, and according he has already ordered his life to that of male. Respondent could have undergo treatment and taken steps like taking lifelong medication to force his body to categorical mold of female, but he did not. He chose not to do so. Nature has instead taken its due course of responded development to reveal more fully is his male characteristic. In that absence of law on matter of the court, he will not dedicate of responded concerning a matter so initially private as one's sexuality and lifestyle. Preference much less on or whether or not do undergo medical treatment to reverse the male tendency due ka. The court will not consider responded as having errand in not choosing to undergo treatment in ordering to become or remain as female. Neither will the court force responded to undergo treatment and to take medication in order to fit the mold of female as society commonly currently know his gender of the human species. Responded is the one who has to live with his intersex anatomy. To him belong a human right to pursue of happiness and of health. To him should be belong to his primordial choice of what courses of action take along the path his sexual development and maturation. In the absence of evidence that responded is an incompetent, and in that absence of evidence to show the classification responded as a male will harm other member of society, who are equally entitled to protection under the law. The court affirms as a valid and justified the respondent position on his personal judgment of being a male. In ruling, we do not more that give respect to the diversity of nature, how individual deal with nature has ended out in the world. We respect responded condition and his mature decision to be a male. Life is already difficult for ordinary person. We cannot be respect how responded deal with his unordinary state of to help make his life easier. Consider the unique circumstance in his case. As for responded change of name under Rule 103, his court has held to change of name in not matter right but the judicial direction to be exercised in the light of the reason of that and the consequence that will follow. The trial court's grant of responded change of name from Jennifer to Jeff implies a change of feminine name to a masculine name. Consider the consequence that responded change name merely recognize his preferred gender. We find merit in responded change of name. Such a change will confirm with the change of the entry in his birth certificate from male to female.